Hello, and welcome to my keynote presentation. Today I will be observing and answering questions about two cases that set the standard for defamation today. In observing these questions, I will bring my own thoughts and opinions, as well as some humor. So Mrs. Tammy, sit back, relax, grab something to eat, and listen to my beautiful voice talk about these two cases. The parties in this case are the New York Times Company, a newspaper in New York, and L.B. Sullivan, the Commissioner of Public Affairs. Sullivan alleged the New York Times had libeled him with an advertisement making false statements about police actions towards students who were part of a civil rights demonstration and against a prominent leader in the civil rights movement. Sullivan said that the leader was him because part of his duties as commissioner was the supervision of the police department. During this time period, public officials, especially the police, were the main targets for media scrutiny because of the resentment of them by the African American community. He felt his reputation was attacked because he was a public official. In this case, the defamation elements are the statements made by the paper, which were that the nonviolent protests were met by a wave of terror by state and local law enforcement. Because he was a government official, he had to prove that the statements that were made in the ad were talking about him specifically and not anyone else. The Supreme Court ruled in favor of Sullivan and awarded him $500,000 for damages to his reputation. The court made this decision because it held that where the words published tend to injure a person libeled by them in his reputation, profession, trade or business, or charge him with an indictable offense, or tend to bring the individual into public contempt, they are libelous per se, that the matter complained of is under the above doctrine, libelous per se if it was published of the concerning the plaintiff, and that it was actionable without proof or pecuniary injury. The court reversed the decision of Alabama law because the courts didn't sufficiently enforce the First and 14th Amendments for public officials. The petitioner was a private person who was hired by a family for a murder trial. The parties in this case are Elmer Gertz, a lawyer, and Robert Welch, aka John Birch Society. An article had appeared in Welch's magazine stating that a Chicago policeman by the name of Nucio was convicted of a murder in the second degree of a young man named Robert Nelson, and he was a part of a communist conspiracy to discredit the local police. It also stated that Gertz had arranged for Nucio's frame-up, had a criminal record, and it labeled him a communist fronter. Since the editors couldn't substantiate their claims, they had no case, and in return nothing was done to verify the allegations against Gertz. I believe that the allegations called his character into question. I also believe that it didn't damage his reputation as much as the lawsuit itself had done. I believe that he ruined his own reputation by going through the lawsuit and losing it. In Georgia, the components for a defamation claim are a false statement about the plaintiff, communication of the statement to a third part in the absence of a special privilege to do so, fault of the defendant amounting at least to negligence and harm to the plaintiff, unless a statement amounts to per se defamation. Something I learned from both of these cases is to use my opinion, but in the right way. I learned how to state facts, but also use my opinion to my advantage. In this field, words have a lot of power, and the best thing that I can do in the future is to choose my words carefully because I can end up hurting someone or helping them. And these are my sources. Thank you so much and have a wonderful day.